Okay, welcome back to the Deep Dive, the place where we take your sources, articles, and research and pull out the crucial nuggets of knowledge to help you get informed quickly, thoroughly, and with maybe more than a few aha moments.
That's right. We're your navigators through the information landscape, helping you understand not just the facts, but why they matter and how they connect. We're translating the detailed source material into a conversation that sticks with you.
And for this deep dive, we are tackling a part of the Indian Constitution that gives the government immense, almost transformative power in times of extreme crisis. We're talking about the emergency provisions.
Mhm. These are contained in Part 8.8 of the Constitution, specifically Articles 352 through 360. And yeah, these aren't rules for business as usual. They are designed for the most abnormal, threatening situations a nation can face.
So our mission today, based on the sources you've given us, is to really pull apart these articles. We need to understand the different types of emergencies the Constitution envisions, why the framers even thought these powers were necessary.
Right. And how they're declared, managed, revoked.
Exactly. And they're truly dramatic effects, and the sources really emphasize dramatic effects on the country's federal structure and its citizens' fundamental rights. And of course, the controversies they've generated and the safeguards that have, well, evolved around them over time.
We're definitely aiming to uncover the essential details and maybe some surprising facts buried in the source material you've shared.
And central to understanding all of this, according to the material, is a core idea highlighted by Dr. B.R. Ambedkar during the Constituent Assembly debates.
Yes. He noted something quite unique about the Indian Constitution. Unlike many other federal systems that are, as he apparently put it, placed in a tight mold of federalism, India's was designed to be adaptable.
Adaptable how?
Well, while it's normally federal, with a clear division of powers between the center and the states, it's specifically crafted so it can operate almost as though it were a unitary system during times of emergency.
That's quite a profound concept. It's not just a minor tweak. It's the potential for the entire political system to fundamentally change its operating structure, from federal to unitary, all within the existing constitutional rules, without needing a whole new amendment just for that switch.
Exactly. It speaks volumes about the framers' concerns, prioritizing national security and stability above the usual structural divisions when a crisis hits.
So let's unpack this. The first question the source addresses is why have these provisions at all? You mentioned they're in Part 8.
Right. And the rationale isn't just theoretical. It's tied to the highest possible stakes. The fundamental purpose, as the source material explains it, is really to enable the central government to effectively meet any abnormal situation. Think of it like the Constitution's toolkit for handling national catastrophes.
Okay, and the high-level goals.
The sources list safeguarding sovereignty, unity, integrity, and security of India, but also, interestingly, protecting the democratic political system and the Constitution itself. So these provisions are framed as necessary tools for the very survival and integrity of the nation.
And this is where that federal to unitary idea really comes into play, right? The source explains that when a proclamation of emergency is active, the central government becomes, and I'm quoting here, all-powerful.
hmm And the states. They aren't dissolved, but they come under the, quote, total control of the center.
It's a temporary transformation, but a massive one.
Yes. The Constitution, federal in normal times, basically converts its structure to a unitary one during an emergency. This ability to adapt federal in peace, unitary in crisis, was seen by the framers, particularly Ambedkar, as a strength. He apparently said the Constitution can be both unitary as well as federal according to the requirements of time and circumstances.
So in normal times, it's federal, but during an emergency, it's so designed as to make it work as though it was a unitary system. It's fascinating that this huge potential for centralizing power is an intended feature built in from day one.
It really highlights the framers' priorities in extreme situations.
Yeah.
National survival and stability seemed paramount.
Okay, so that's the rationale. Now, the Constitution clearly distinguishes three different types of emergencies that can trigger these special powers.
Yes, 3 distinct types.
Right. The first one, the one most people probably think of as national emergency, is under Article 352. This is triggered by threats like war, external aggression, or armed rebellion. And the Constitution itself calls this a proclamation of emergency.
Correct. Then there's the second situation, which arises from the failure of constitutional machinery in states. That's Article 356.
Ah, the one commonly known as President's Rule in a state.
Exactly. People sometimes call it a state emergency or constitutional emergency, but it's worth noting, and the source points this out, that the Constitution itself doesn't actually use the word emergency for this specific situation under Article 356.
Okay, that's a useful distinction. So President's rule isn't technically labeled an emergency in the text, even if it feels like one. And the third type.
The third is the financial emergency under Article 360. This one's triggered when there's a threat to the financial stability or credit of India.
Got it. So national emergency, Art 352, President's rule, Art 356, and financial emergency, Art 360. Let's dig into each one, starting with the big one, the national emergency under Article 352. What are the specific grounds for declaring this?
Okay, Article 352 says a national emergency can be declared when the security of India, or even just a part of it, is threatened by, well, three things: war, external aggression, or armed rebellion.
And the source points out it's not purely reactive. The president can declare it before the actual fighting or rebellion starts?
Yes, if they are satisfied that there's an imminent danger of it happening,
Yeah.
that power to anticipate is significant.
But the grounds themselves, there's a really interesting history with one of them, isn't there? Specifically the armed rebellion part.
Oh, absolutely. This reveals a crucial evolution. The original Constitution didn't say armed rebellion. It used the term internal disturbance.
And that distinction is absolutely critical because of what happened in 1975.
Precisely. As the source explains, the phrase internal disturbance was seen as, well, frankly, too vague and had a wider connotation. The experience of the 1975 emergency, which was declared based on internal disturbance.
That led directly to the 44th Amendment Act of 1978.
Yes. And that amendment replaced internal disturbance with the much more specific, much narrower term, armed rebellion.
So just to be clear for our listeners, a national emergency cannot be declared now on the same vague ground used back in 1975. That's a direct constitutional lesson learned from history.
Absolutely. The shift to armed rebellion was meant to ensure only a severe internal armed uprising, not just, say, civil unrest or political protests, could trigger this extreme measure.
But the source also makes a distinction between external emergency, meaning war or external aggression, and internal emergency, which is the armed rebellion ground.
Right. And it also notes the 42nd Amendment back in 1976 allowed the proclamation to be limited to just a part of India, not necessarily the whole country.
Okay, so those are the grounds and how one ground changed significantly. What about the actual process? Who decides, and are there checks?
This is another area where the 1975 experience led to a fundamental change, again, thanks to that 44th Amendment. Before 1978, the president could declare a national emergency based simply on the advice of the prime minister.
And in 1975, the source points out, the then Prime Minister Indira Gandhi advised the president to issue the proclamation, well, without actually consulting her own cabinet ministers first.
That's the key detail. The cabinet was apparently only informed after the emergency was declared. It was presented as a done deal, a fait accompli.
That sounds quite problematic for collective responsibility.
It was seen as such. So to prevent that kind of unilateral decision-making by the PM alone, the 44th Amendment introduced a really crucial safeguard. The president can now proclaim a national emergency only after receiving a written recommendation from the cabinet.
Written recommendation from the whole cabinet.
Yes, the entire cabinet has to agree and put it in writing.
Wow. That's a huge check on executive power. It ensures such a massive decision needs collective agreement, not just the PMs say so. Okay, and once it's declared, can the courts review it? Was that always possible?
Judicial review over the declaration. That's also seen a bit of a back and forth. Initially, the 38th Amendment Act of 1975 passed during the 1975 emergency, mind you, explicitly made the president's satisfaction in declaring the emergency final and immune from judicial review. Basically, they tried to keep the courts out.
But the 44th Amendment walked that back.
It did. The 44th Amendment in 1978 deleted that provision, making the declaration subject to judicial review again. And the Supreme Court really cemented this in the landmark Minerva Mills case in 1980.
Right. Minerva Mills, what did the court say there?
The court held that, yes, a proclamation of national emergency can be challenged in court. Now, the grounds aren't about whether it was a good political idea.
Right. Courts don't usually get into policy wisdom.
Exactly. But they can challenge it if it was based on malafide, meaning bad faith or malicious intent, or if the decision was based on wholly extraneous and irrelevant facts, or if the decision was just plain absurd or perverse.
Okay, so the courts won't second-guess the political judgment if it's made properly, but they will check if the power was used for the wrong reasons or based on nonsense, essentially. That seems like a significant judicial check.
It is. It provides an important layer of accountability. The executive can't just declare an emergency arbitrarily and expect it to be totally immune from scrutiny.
Okay, so we have the grounds, the critical cabinet safeguard in the process, and judicial review. Now, once a national emergency is declared, how does Parliament get involved and how long can it last?
Right. Parliament's role is crucial. The proclamation must be approved by both houses of Parliament within 1 month from the date it was issued.
1 month? That seems quick.
It is, and it was actually reduced from 2 months by the 44th Amendment, another change, tightening the timeline for legislative approval.
What happens if the Lok Sabha, the lower house, isn't sitting or dissolves during that critical 1 month window?
Good question. If the Lok Sabha is dissolved when the proclamation is made, or dissolves within that month before approving it, the proclamation stays active until 30 days after the new Lok Sabha first meets, provided the Rajya Sabha, the upper house, has approves it in the meantime. So the Rajya Sabha's approval is key to bridging that gap.
Okay. And once both houses do approve it, how long does the emergency continue?
It continues for 6 months.
Just 6 months?
Initially, yes. But here's another critical change from the 44th Amendment. It can be extended for an indefinite period, but, and this is the key part, only with fresh parliamentary approval every single 6 months.
So periodic checks every 6 months. That sounds much more controlled than just letting it run indefinitely after the first approval.
Exactly. Before the 44th Amendment, once Parliament gave that initial okay, the emergency could technically continue for as long as the executive wanted, without needing further votes. This 6-month renewal requirement forces a regular review and prevents the executive from just keeping the emergency going without ongoing legislative oversight.
Makes sense. And what kind of majority is needed in Parliament for this approval or extension? Is it just a simple majority?
No, and this is another really important safeguard from the 44th Amendment. Every resolution approving the proclamation or approving its continuation every 6 months must be passed by a special majority in both houses.
Special majority. Remind us what that means.
It means 2 conditions have to be met. First, a majority of the total membership of that house must vote in favor. And second, a majority of not less than 2/3 of the members of that house who are actually present and voting must approve it.
Okay, so that's a significantly higher bar than a simple majority.
Much higher. The requirement used to be a simple majority before the 44th Amendment. Raising the threshold makes it considerably harder to get and maintain parliamentary backing for an emergency.
So summing up the 44th Amendment's impact here. Written cabinet advice, shorter initial approval time, special majority needed for approval and continuation, and mandatory 6-month reviews. Seems like a real effort to tighten the reins. How is a national emergency ended or revoked?
Well, the president can revoke a proclamation of emergency at any time just by issuing a subsequent proclamation. And importantly, this revocation doesn't need any parliamentary approval.
So the president can just decide, okay, it's over.
Yes, they have that power. But again, the 44th Amendment introduced a crucial check from the other side. The president must revoke the proclamation if the Lok Sabha passes a resolution disapproving its continuation.
Wait, the Lok Sabha, just the lower house, can force the president to end the emergency? That gives the directly elected house significant power here.
It really does. This was a major safeguard introduced by the 44th Amendment. Before this, the Lok Sabha had no control over revocation. Now, if they vote against continuing it, the president has no choice but to end it.
And how can the Lok Sabha even get to vote on disapproval? Is there a mechanism?
Yes, the 44th Amendment provided one. If 1/10 of the total members of the Lok Sabha give a written notice to the Speaker, or to the President if the House isn't in session, a special sitting of the House must be held within 14 days, specifically to consider a resolution disapproving the continuation of the emergency.
So a significant minority in the Lok Sabha can trigger a vote that could potentially end the emergency. That feels like a strong democratic check. And the source highlights a difference in the majority needed for disapproval versus approval, right?
Yes, and it's another way the system kind of leans towards ending it once initiated. A resolution of disapproval by the Lok Sabha requires only a simple majority to pass.
Simple majority to stop it.
Compared to the special majority required in both houses to start it or keep it going. It's deliberately made easier to stop it than to approve or continue it.
Okay, now for the really big question. What are the actual effects when a national emergency is in operation? Our source calls these consequences drastic and wide-ranging on the political system.
And they truly are. They fundamentally alter the normal structure and balance of power in India. We can break them down into 3 main areas: the impact on center-state relations, the effect on the life of legislatures, and critically, The effect on fundamental rights.
Let's start with center-state relations. How does that normal federal balance shift?
Well, this is where that unitary transformation really kicks in. In the executive sphere, the center's power expands dramatically. It can give directions to any state government on how to exercise its executive power on any matter.
Any matter. Normally, the center can only direct states on specific things.
Exactly. During a national emergency, that limitation disappears. The state governments aren't suspended, they still exist, but their executive functions basically come under the complete control of the center.
So the state government is still there, but it essentially operates under central command.
Pretty much.
Yeah.
Legislatively, Parliament gains the power to make laws on any subject listed in the state list topics normally reserved exclusively for state legislatures.
Wow. So Parliament can just start making laws about, say, local policing or agriculture for a specific state?
Yes, the state legislatures aren't suspended. They can still technically pass laws, but Parliament's power becomes overriding. If Parliament makes a law on a state subject, it prevails. The normal distribution of legislative powers is essentially suspended.
That's the unitary shift in lawmaking power, loud and clear. Are these laws permanent?
No, laws made by Parliament on state subjects during the emergency are temporary. They become inoperative 6 months after the emergency ends. Also, when Parliament isn't in session, the president gets the power to issue ordinances, which are like temporary laws on state subjects.
Ordinance power over state matters, too. That's a huge centralization.
It is, and the 42nd Amendment in 1976 also broadened the reach. Before that, these effects might primarily apply just where the emergency was operating. After the 42nd, these executive and legislative powers could extend to any other state as well, even if the emergency wasn't directly proclaimed there.
Okay, so the geographic scope of central control expands significantly. What about financially? Does the center get control over state money, too?
Yes. In the financial sphere, the president gains the power to modify the constitutional distribution of revenues between the center and the states.
What does that mean in practice?
It means the president could, for example, order a reduction or even cancellation of the financial transfers, things like grants or the state's share of taxes from the center to the states. This order lasts until the end of the financial year in which the emergency ceases and has to be presented to the Parliament.
Okay, so executive, legislative, and financial control over the states all shifts heavily towards the union government. What about the life of the legislatures themselves, the Lok Sabha and the state assemblies? Can their terms be affected?
Yes, this is another area with significant impact. While a national emergency is in operation, the normal 5-year term of the Lok Sabha can be extended.
Extended by how much?
By a law passed by Parliament for 1 year at a time. And this can be done repeatedly for any length of time while the emergency is active.
1 year at a time, with no theoretical limit as long as the emergency is on. That's an incredibly powerful effect on democratic timelines.
It is. But there's a crucial limit once the emergency ends. The source clarifies that this extension cannot continue for more than 6 months after the emergency has ceased to operate.
Is there a historical example of this happening?
Yes. The source mentions the 5th Lok Sabha, which was elected in 1971. Its term was extended twice due to the emergency's active then, and it ended up lasting until 1977.
And does the same rule apply to state legislative assemblies? Can their terms also be extended?
Yes, Parliament can similarly extend the normal 5-year tenure of a state assembly by 1 year at a time, for any length during the emergency, also subject to that same maximum period of 6 months after the emergency ends.
Right. Now let's move to what might be the most sensitive and often debated effect, the impact on fundamental rights. How does a national emergency affect the rights guaranteed to citizens under Part 3 of the Constitution? This is crucial.
It absolutely is. And this is handled by 2 distinct articles, Article 358 and Article 359. It's really important to understand the difference between them.
Okay, let's break it down. Article 358 first. What does that one do?
Article 358 deals specifically with the suspension of the fundamental rights guaranteed under Article 19. These are the 6 rights related to freedom of speech and expression, assembly, association, movement, residence, and profession.
And what happens to these Article 19 rights under 358?
According to Article 358, when a proclamation of national emergency is made, these 6 fundamental rights under Article 19 are automatically suspended.
Automatically, just like that. No separate order needed.
Exactly. It happens the moment the emergency is declared. The state is basically freed from the restrictions imposed by Article 19 during the emergency. It can make laws or take executive actions that restrict or take away these 6 rights.
And these actions cannot be challenged in court on the grounds that they violate Article 19, at least during the emergency.
Correct. Once the emergency ends, Article 19 automatically revives, and any laws made during the emergency that are inconsistent with it cease to have effect going forward.
But the source emphasizes a really stark point here. No remedy lies for anything done during the emergency, even after the emergency expires. What does that mean?
It means if the government took an action during the emergency that violated your Article 19 rights, an action you couldn't challenge at the time, you can't go back and sue them for damages or get that action invalidated after the emergency is over, what's done is done, essentially.
That's quite drastic. But this is also where the 44th Amendment made major changes to Article 358, right? It wasn't left quite that wide open.
Absolutely. The 44th Amendment Act of 1978 significantly reigned in Article 358. Firstly, and this is huge, the automatic suspension of Article 19 rights happens only when the national emergency is declared on the ground of war or external aggression.
Ah, okay. So if the emergency is declared on the ground of armed rebellion, the internal emergency ground we discussed earlier.
In that case, the rights under Article 19 are not automatically suspended by Article 358. This was a key change, a direct lesson from 1975, ensuring these core freedoms aren't automatically curtailed during an internal crisis unless it's linked to external threats.
That's a major safeguard. And the second restriction from the 44th Amendment.
Just as important. Only those laws that are specifically related to the emergency and executive action taken under such a law are protected from challenge on Article 19 grounds when it applies.
Right.
The state can't just pass any old law violating Article 19 and claim protection simply because there's an external emergency on. The law has to be connected to the emergency itself.
Okay, so Article 358, automatic suspension of Article 19, but only for external emergencies now, and only protects emergency-related actions.
Got it. Now, how does Article 359 differ? That one deals with other fundamental rights, right?
Yes. Article 359 works differently. It doesn't automatically suspend the rights themselves. Instead, it authorizes the president, through a specific order, to suspend the right to move any court for the enforcement of specified fundamental rights during a national emergency.
Okay, slow down. So the rights themselves, like, say, the right to equality under Article 14, technically still exist.
Theoretically, yes.
But if the president's order under Article 359 lists Article 14, you lose the ability to go to court to protect that right.
Exactly. The rights are theoretically alive, but they become unenforceable in court for the period the president's order is in effect. The order has to specify which fundamental rights enforcement is being suspended, for how long, it could be shorter than the emergency itself, and whether it applies to the whole country or just a part. And this presidential order has to be laid before Parliament for approval. So if my right to equality is listed in the order, the government could potentially discriminate against me during that time, and I'd have no legal recourse through the courts.
That's the potential effect for the rights specified in the order. The state can make laws or take executive actions that infringe on those specified rights, and those actions cannot be challenged in court, while the president's order covering them is operational. And similar to Article 358, the source notes that no remedy lies for anything done during the operation of the order, even after the order ceases to operate.
This sounds like it gives the executive immense power to potentially violate a wide range of rights as long as they are listed in that presidential order under Art 359. But this is also where the 44th Amendment introduced another absolutely crucial safeguard, isn't it? Perhaps the most fundamental one.
Yes, and this is arguably the single most vital protection for citizens during an emergency. The 44th Amendment Act of 1978 placed two major restrictions on Article 359. Most importantly, it states that the president cannot suspend the right to move the court for the enforcement of fundamental rights guaranteed by Articles 20 and 21.
Articles 20 and 21. That's protection in respect of conviction for offenses, things like double jeopardy, self-incrimination, and, of course, the right to life and personal liberty.
Precisely. The 44th Amendment made it crystal clear. The rights to protection under Article 20 and the fundamental right to life and personal liberty under Article 21 remain enforceable even during a national emergency. The president cannot issue an order under Article 359 to suspend your right to go to court if these two specific rights are violated.
Wow. So your right to life, your right to liberty, your basic protections if accused of a crime, those are sacrosanct, constitutionally protected even in the gravest national crisis. You can always go to court for those.
That's the line the Constitution draws. And the second restriction under Article 359 is similar to the one added to Article 358, protection from challenge, is only for laws that are related to the emergency and for executive action taken under such a law.
That protection for Articles 20 and 21 feels like a profound constitutional anchor. No matter what, those core rights and your ability to enforce them remain.
Okay, the source provides a helpful table comparing 358 and 359. Can we quickly summarize the key takeaways from that comparison for listeners? It helps clarify things. Sure, the core differences boil down to this. Art 358 affects only Article 19 rights. Art 359 can affect other specified rights, but never 20 and 21 after the 44th Amendment. Art 358 means automatic suspension of Art 19 rights themselves. Art 359 gives the President the power to suspend the enforcement, going to court, for other specified rights via an order. After the 44th Amendment, Art 358 only operates during an external emergency or external aggression. Art 359 can operate during both external and internal emergencies. Art 358 suspends Art 19 for the entire emergency duration. Art 359 suspends enforcement only for the period specified in the President's order, which can be shorter. Art 358 generally applies countrywide. Art 359 can apply to the whole country or just a part. And the critical difference, Art 358 suspends Art 19 within its limited scope now. Art 359 cannot touch the enforcement of Articles 20 and 21 at all.
Okay, that's clear. One is automatic for Art 19, only in external crises now. The other needs a specific order to block court access for other rights, but has that absolute exception for Articles 20 and 21.
Right. And both now share the condition that only actions actually related to the emergency get legal protection on those grounds.
Right. Okay, that covers the complex constitutional framework for national emergency and its pretty dramatic effects, especially on rights. Now, let's look at national emergency in practice. Our source states it has actually been proclaimed 3 times in India's history.
That's correct, 3 times. 1962, 1971, and 1975.
Can you walk us through them briefly?
Sure. The first was in October 1962. This was in response to the Chinese aggression on India's northern borders in what was then NEFA, now Arunachal Pradesh. This emergency actually lasted a long time, until January 1968, so it also covered the period of the 1965 war with Pakistan. The ground was clearly external aggression.
Okay, and the second instance?
The second was declared in December 1971 during the war with Pakistan that led to the creation of Bangladesh. This was also based on the ground of external aggression. And interestingly, this 1971 emergency was actually still technically in operation when the third one was declared in 1975.
Right, the third one. The one the source explicitly calls the most controversial.
Yes, that was declared in June 1975. And the ground given this time was internal disturbance. The proclamation specifically mentioned things like, certain persons have been inciting the police and the armed forces against the discharge of their duties. As the source notes, this 1975 emergency really did prove to be the most controversial in India's history, leading to, quote, widespread criticism of the misuse of emergency powers.
And this controversy had very real political consequences, didn't it?
Oh, absolutely. The public backlash against the emergency was seen as a major factor in the ruling Congress Party's big defeat in the 1977 Lok Sabha elections. A new coalition government, the Janata Party, came to power.
And they took specific action regarding that 1975 emergency.
They did. They appointed the Shah Commission of Inquiry to investigate the circumstances that led to the declaration of the 1975 emergency and also the alleged excesses and abuses of power that occurred during that period. The source points out that the Commission's findings essentially concluded that the declaration of the emergency was not justified.
So this whole historical episode, the 1975 emergency, the public reaction, the election defeat, the Shah Commission finding it unjustified, this is the direct context, the direct reason the Constitution was changed so significantly afterwards.
Exactly. The 44th Amendment Act of 1978, which we keep coming back to because it introduced so many safeguards, was a direct outcome of this experience. It was specifically designed to try and prevent that kind of perceived misuse from happening again.
It's a powerful example of how constitutional law isn't just abstract. It evolves directly in response to major national events and political accountability. The 1975 emergency fundamentally reshaped the rules around national emergency in India.
Absolutely. It's a stark reminder of the potential power, the potential danger inherent in these provisions.
Okay, let's shift gears now to the second type of situation, President's rule under Article 356. And again, remembering the Constitution doesn't technically label this one an emergency.
Right. President's rule is closely linked to the center's responsibility outlined in Article 355. This article puts a duty on the Union government to protect every state from external aggression and internal disturbance. And this is the key part for 356, to ensure that the government of every state is carried on in accordance with the provisions of the Constitution.
Okay, so President's rule is basically the center stepping in when that last part ensuring the state government is following the Constitution, breaks down.
Precisely. It comes into play upon the failure of constitutional machinery in state. The power to impose president's rule under Article 356 can be triggered based on two main grounds, according to the source material.
What are those two triggers?
The first is in Article 356 itself. The president needs to be satisfied that a situation has arisen where the state government simply cannot be carried on according to the Constitution. Now, this satisfaction can be based either on a report received from the state's governor.
Or otherwise. That or otherwise phrase seems important again.
It is. It means the president isn't strictly bound by the governor's report. They can potentially act based on other information or sources, even if the governor hasn't formally reported a breakdown.
Okay, that's the first ground. And the second?
That's under a different article, Article 365. It states that if a state government fails to comply with, or fails to give effect to, any direction given by the center, within the center's constitutional power to give directions, then the president is lawfully entitled to deem that a situation has arisen where the state government cannot be run constitutionally.
So simply not following central directives can be a direct trigger for president's rule?
Under Article 365, yes, that's what it allows the president to conclude.
Right. Now, once president's rule is proclaimed for a state, what's the process for parliamentary approval, and how long does it typically last?
Okay, a proclamation imposing president's rule must be approved by both houses of parliament within 2 months from the date it was issued.
2 months? That's longer than the 1 month for national emergency.
It is. 2 months for president's rule. The rule about Lok Sabha dissolution is similar. If it's dissolved when the proclamation is made or within the 2 months, it survives for 30 days from the new Lok Sabha's first sitting, as long as the Rajya Sabha approves it within the initial 2 months.
Okay. And if both houses approve it within 2 months, how long does president's rule continue?
If approved, it continues for 6 months.
Same initial period as national emergency. Can it be extended?
Yes, it can be extended repeatedly with parliamentary approval every 6 months. But, and this is a major difference from national emergency, there is a strict overall maximum period of 3 years for president's rule.
Ah, okay. So unlike national emergency, which can theoretically be extended indefinitely as long as Parliament approves every 6 months, president's rule has a hard stop at 3 years. And what kind of majority is needed in Parliament for approving or extending president's rule?
This is another significant difference. Resolutions approving the proclamation of president's rule, or its continuation, only need to be passed by a simple majority in either House of Parliament.
Simple majority. Wow, that's a much lower threshold than the special majority needed for national emergency. That makes getting parliamentary approval and extensions for president's rule considerably easier.
It certainly does. However, the 44th Amendment did introduce a crucial restraint, specifically on extending president's rule beyond 1 year. This was another safeguard aimed at preventing its prolonged use without very strong justification.
Okay, what's that restraint for going beyond 1 year?
The 44th Amendment mandated that president's rule can only be extended by 6 months at a time beyond the initial 1-year period if two very specific conditions are both met simultaneously.
What are they?
First, a national emergency, under Article 352, must be in operation, either in a whole of India or in the whole or any part of the state concerned.
So, to keep president's rule going past 1 year, there has to be a separate, concurrent national emergency happening.
That's the first requirement. And the second condition is that the Election Commission of India must certify that holding general elections to the State Legislative Assembly is impossible due to difficulties.
Wow. So, both a national emergency and the Election Commission saying elections are impossible. That makes extending president's rule beyond 1 year extremely difficult, reserved only for genuinely extraordinary combined crises.
That seems to be the clear intent. It aims to prevent the center from ruling a state indefinitely for ordinary political reasons. The source does note a historical exception for Punjab in the late 80s, early 90s, where president's rule was extended beyond 3 years due to the specific security situation there, requiring a constitutional amendment for that specific case.
Understood. And how is president's rule revoked or ended?
The president can revoke a proclamation of president's rule at any time, just by issuing a subsequent proclamation. And this revocation does not require any parliamentary approval.
And unlike national emergency, there's no provision for the state assembly or the Lok Sabha to somehow force the president to revoke it.
That's correct, according to the source. The mechanism for legislative compulsion to revoke exists for Article 352, national emergency. But the source indicates it does not exist for Article 356, president's rule.
Okay. Now, what are the practical consequences when president's rule is actually imposed? What powers does the center or the president actually assume in the state?
The president acquires some really quite extraordinary powers. They can take over all the functions of the state government and all the powers that were vested in the governor or any other executive authority in the state. The president can also declare that the powers of the state legislature will now be exercised by or under the authority of Parliament.
So the elected state government is effectively removed from power.
Yes. In practice, the president dismisses the State Council of Ministers, which is headed by the chief minister. The state governor then administers the state directly, acting on behalf of the president. Often, the governor is assisted by the state's chief secretary or advisors appointed specifically by the president. This is why it's commonly called president's rule.
And what happens to the state legislative assembly itself?
The president typically either suspends the state legislative assembly or dissolves it altogether. If it's dissolved, obviously, fresh elections have to be held at some point to reconstitute it. While the assembly is suspended or dissolved, Parliament takes over the legislative functions for that state. Parliament passes the state's legislative bills and also the state budget.
Parliament making laws for a specific state, there's that unitary shift again in a different context.
Exactly. And Parliament can even delegate its power to make laws for that state to the president or to another authority specified by the president. The source mentions the practice where the president makes these laws after consulting with the members of Parliament from that particular state. These are often referred to as President's Acts.
So the center is running the executive and legislative branches of the state. What about authorizing spending?
The president can authorize expenditure from the state consolidated fund, basically, the state's main bank account when the Lok Sabha isn't in session. But this spending is subject to subsequent sanction by Parliament once it meets.
Are the laws made during president's rule temporary, like some of the laws made during a national emergency?
No, the source clarifies this. Laws made by Parliament or the president or their delegate while president's rule is in force actually continue to be operative even after the president's rule ends. Their validity isn't tied to the duration of the proclamation.
So they remain on the books.
Yes, but once the state legislature's powers are restored, either the suspended assembly is revived or a new one is elected, that state legislature is then free to repeal, alter, or reenact those laws made during president's rule.
Is there anything significant that is explicitly not affected by president's rule? Any institution left untouched?
Yes, and this is important. The president cannot assume the powers vested in the concerned state high court or suspend any constitutional provisions relating to the high court. The constitutional position, status, powers, and functions of the state high court remain exactly the same, ensuring judicial independence at the state level is maintained even during central rule.
Okay, so extensive central control over the state executive and legislature, but the high court remains independent. Now let's get into the controversy. Our source doesn't pull any punches here, calling Article 356 one of the most controversial and most criticized provisions of the Constitution. Why so much criticism?
Well, the source points to its frequency of use and the manner of its use. Since 1950, President's rule has been imposed well over 125 times, affecting almost every single state in India at some point or another. And the source explicitly states that on a number of occasions, President's rule has been imposed in an arbitrary manner for political or personal reasons, rather than for a genuine breakdown of constitutional machinery as intended.
Can you give us some of the specific examples cited in the source of this alleged misuse, these arbitrary impositions?
Sure. One prominent example mentioned is what happened after the 1977 Lok Sabha elections. The ruling Congress Party lost power nationally for the first time, and the Janata Party formed the government at the center. This new Janata government then proceeded to impose President's rule in 9 states where the Congress Party was still in power.
On what grounds?
The stated ground was highly controversial, that these state assemblies, elected earlier, no longer represented the wishes of the electorate, as supposedly shown by the results of the national election.
And then, when the Congress Party returned to power nationally in the 1980 Lok Sabha elections.
According to the source, they did exactly the same thing in reverse. The new Congress government dismissed 9 state governments run by other parties, using the very same justification that the state assemblies didn't reflect the people's will after the national election results.
So it became almost a tit-for-tat pattern of political retribution, using Article 356 almost like a tool to consolidate power or punish opponents after winning a national election, rather than responding to a genuine constitutional crisis within the state.
That's precisely the criticism leveled against those instances. Another example cited in the source is the imposition of President's Rule in 3 BJP-ruled states in 1992. The ground given was that these state governments were not sincerely implementing a ban that the center had imposed on certain religious organizations. The controversy there was whether a disagreement on implementing a central policy, even an important one, truly amounted to a failure of constitutional machinery.
These examples really paint a picture of the concerns that Article 356, intended as an emergency measure, was often used for political leverage or convenience.
And this really brings us back to Dr. B.R. Ambedkar's original comments on Article 356 during the Constituent Assembly debates. He had expressed the hope, the source reminds us, that this power would remain a dead letter, something rarely, if ever, used, and only as an absolute measure of last resort, to avoid unnecessarily infringing on the state's autonomy. He knew it was a drastic power.
But the reality, based on the history presented in the source, has been starkly different from that hope.
Sadly, yes. As the source puts it, quite dramatically, what was hoped to be a dead letter of the Constitution has turned to be a deadly weapon against a number of state governments and legislative assemblies. There's a famous quote attributed to H.V. Kamath, another Constituent Assembly member, years later. Dr. Ambedkar is dead and the articles are very much alive. It's a poignant commentary on how the provision's actual use seemed to deviate so far from its intended exceptional nature.
Okay, given this history of controversy and alleged improper use, how did the judiciary respond? Did the courts eventually step in to try and regulate the use of Article 356?
Yes, thankfully, the judiciary has played a crucial role here in trying to curb the misuse of Article 356. Just like with national emergency, the 38th Amendment back in 1975 had initially tried to make the president's satisfaction in invoking Article 356 final and completely immune from judicial challenge.
But again, the 44th Amendment in 1978 removed that immunity.
Exactly. The 44th Amendment deleted that provision, which explicitly opened the door for judicial review of the president's satisfaction under Article 356. This led to a number of court challenges over the years, culminating in the really landmark S.R. Bommai versus Union of India case decided by the Supreme Court in 1994.
Ah, the Bommai case. That's often cited as a watershed moment, isn't it? Really trying to rein in the misuse of Article 356. What were the key principles or guidelines the Supreme Court laid down in that case, according to our source material?
The Bommai judgment is incredibly important, yes. It basically established a set of clear rules and checks on the center's power under Article 356, significantly limiting the scope for arbitrary action. Here are some of the key propositions the source highlights. First, the presidential proclamation imposing president's rule is absolutely subject to judicial review. The courts can look at it.
No more immunity.
Right. Second, the president's satisfaction, the belief that constitutional machinery has failed, must be based on relevant material. The court can actually strike down the proclamation if it finds it was based on irrelevant or extraneous grounds, or if it was found to be malified, meaning made in bad faith or for improper motives, or simply perverse.
So the center has to have actual relevant reasons.
Yes. And third, the burden of proof lies squarely on the center to demonstrate to the court that such relevant material actually existed to justify the imposition. They have to prove their case.
Okay, the onus is on the center.
Fourth, the court clarified its role. It will examine the relevance of the material presented, not necessarily its correctness or adequacy. The question is whether the reasons could constitutionally justify the action, not whether the court agrees it was the best decision politically.
A focus on legality, not policy. Makes sense.
Fifth, and this is a huge one, if the court finds the proclamation unconstitutional and invalid, it has the power to restore the dismissed state government and revive the state legislative assembly if it had been suspended or dissolved.
Wow, the court can actually undo the president's rule and put the old government back in power. That's a powerful check.
It's a massive deterrent against misuse. Sixth, the court ruled that the state legislative assembly should be dissolved only after Parliament has approved the proclamation of president's rule. Until that parliamentary approval comes, the assembly can only be suspended, not dissolved.
Why is that significant?
It prevents the irreversible step of dissolution before the center has even secured parliamentary backing. If Parliament fails to approve the proclamation, the suspended assembly would simply reactivate. It keeps options open.
Okay, what else came out of Bommai?
Seventh, The court declared that secularism is a basic feature of the Constitution, meaning it's so fundamental it can't be amended away. Therefore, a state government actively pursuing anti-secular politics could be liable for action under Article 356. The source notes the court actually upheld the 1992 dismissals of certain state governments on this specific ground.
Interesting, linking constitutional values to Article 356.
Eighth, the crucial principle of the floor test. The court said the question of whether a state government has lost the confidence of the assembly should be decided only on the floor of the House through a vote. The governor or president cannot just dismiss a ministry based on their own headcount or assessment of support without a proper floor test.
The floor test principle that's fundamental to parliamentary democracy.
Absolutely. Ninth, the court directly addressed the 1977-1980 type dismissals. It ruled that a new political party taking power at the center does not have the authority to dismiss state ministries formed by other parties simply because they belong to a different party.
Closing that loophole.
And finally, 10th, the court reiterated that the power under Article 356 is an exceptional power. It should be used only occasionally, sparingly, and strictly to meet the requirements of genuine special situations, not as a routine political tool.
These Baumai propositions really seem transformative. They shift the balance back towards federalism and accountability, demanding justification from the center, empowering courts to intervene decisively, and setting clear procedural and substantive limits like the floor test and the bar against purely political dismissals.
Exactly. And building on the Baumai judgment, as well as recommendations from bodies like the Sarkaria Commission, which examines center-state relations, the source provides helpful lists of situations generally considered proper versus those considered improper for imposing president's rule.
Okay, can you give us a few examples of what are now considered proper grounds according to these guidelines?
Sure. Proper situations generally include things like hung assembly after elections, where absolutely no party or coalition can form a stable government, or where the party with a majority refuses to form a government and no alternative is possible, or where a ministry resigns or is clearly defeated on the floor of the House, and again, no other party can form a viable government. Also, situations where a state government deliberately disregards constitutional directions from the center, especially those related to national security or unity, or instances of actual internal subversion where the state government itself is acting against the Constitution, or a complete physical breakdown of law and order.
So genuine deadlock or breakdown situations, what about the improper grounds? The situations where a president's rule should not be imposed according to these guidelines.
Improper grounds would include things like the governor recommending PR without first exploring all possibilities of forming an alternative government, or the governor dismissing a ministry based on their subjective assessment of support without a floor test, or imposing PR simply because the ruling party in the state performed poorly in national Lok Sabha elections.
So explicitly rejecting the 1977-1980 rationale.
Correct. Also considered improper are internal disturbances that don't actually amount to a constitutional breakdown or subversion, or using Article 356 merely to address allegations of maladministration, corruption, or financial problems in the state, as these, while serious, aren't typically seen as failure of constitutional machinery in themselves, or imposing it without giving the state government a prior warning to rectify the situation unless there's extreme urgency.
So things like just bad governance or financial issues are explicitly not proper reasons for president's rule, according to the Supreme Court and expert commissions. It has to be a constitutional failure.
That's the standard set. It's also considered improper to use Article 356 just to sort out internal squabbles within the ruling party in the state, or for any other purpose that's extraneous or irrelevant to the actual constitutional grounds. These guidelines collectively aim to restrict president's rule back to being a measure for genuine constitutional breakdown, trying to align it more closely with Ambedkar's original last resort idea.
Okay, 2 down, 1 to go. Let's look at the third and final type of emergency situation provided for in the Constitution, the financial emergency under Article 360.
Right. The ground for declaring a financial emergency is quite straightforward. The president needs to be satisfied that the situation has arisen which threatens the financial stability or credit of India or any part of its territory.
And is the president's satisfaction here also subject to judicial review following the pattern we saw with the other two after the 44th Amendment?
Yes, the source confirms the same evolution. The 38th Amendment had tried to make it immune, but the 44th Amendment removed that immunity. So the president's satisfaction in declaring a financial emergency is indeed subject to judicial review.
Okay. How is a financial emergency approved by Parliament? And crucially, How long does it last?
A proclamation declaring a financial emergency must be approved by both houses of parliament within 2 months from the date of its issue. The Lok Sabha dissolution rule is similar to the other two emergencies.
2 months for approval. And the duration. Is there a 6-month review cycle like national emergency or a 3-year maximum like president's rule?
Here's where financial emergency is unique, and the source highlights this key distinction. Once a financial emergency is approved by both houses of parliament, it continues indefinitely until it is specifically revoked.
Indefinitely. Just like that. Without needing repeated parliamentary approval every 6 months.
That's exactly right. There is no maximum period prescribed for its operation in the Constitution, and repeated parliamentary approval is not required for its continuation once it has received that initial approval.
Wow. And what majority is needed for that initial approval?
The approval itself requires only a simple majority in either house.
Okay, let me get this straight. A simple majority approval in Parliament and then a financial emergency can potentially last forever, or at least until the president decides to end it. That's a remarkably different structure.
It is indeed a significant difference compared to the other two. The president can, of course, revoke the proclamation at any time by issuing a subsequent proclamation, and that revocation does not require parliamentary approval.
Right. So what are the effects or consequences of a financial emergency? What kind of powers does the center gain when one is in operation?
During a financial emergency, the center essentially acquires full control over the states in financial matters. The executive authority of the union can issue directions to any state government to observe specific canons of financial propriety, basically, rules for sound financial management, and any other directions the president deems necessary for maintaining financial stability.
What kinds of necessary directions are we talking about?
Well, these directions can include provisions requiring a state government to reduce the salaries and allowances of all or any class of persons serving in connection with the affairs of the state.
So the center can order pay cuts for state government employees.
Yes. The directions can also require that all money bills or other financial bills passed by the state legislature must be reserved for the president's consideration after they've been passed by the state legislature.
Direct central power to cut state employee salaries and effectively veto state financial legislation. That's incredibly significant control.
And here is perhaps the most striking power mentioned in the source. The president may issue directions for the reduction of salaries and allowances of all or any class of persons serving the union.
Okay, so central government employees too.
And the judges of the Supreme Court and the high courts.
Wait, hang on. Even the salaries and allowances of Supreme Court and high court judges can be reduced by the president during a financial emergency.
Yes, the source explicitly states this power exists under Article 360. It really highlights the extraordinary reach of central authority envisaged in a severe financial crisis, extending even to the emoluments of the higher judiciary, which are normally constitutionally protected to ensure independence.
That's quite something. I remember the source mentioned H.N. Kunzru in the Constituent Assembly, expressing serious concern that these provisions pose a major threat to the financial autonomy of the states.
He did. And Dr. Ambedkar apparently provided some context by referencing the U.S. National Recovery Act of 1933, enacted during the Great Depression, suggesting these powers were conceived with truly dire economic circumstances in mind.
Yes, placing it in that historical context of a potential catastrophic economic collapse. Now, given the immense power these provisions grant over national and state finances, and the fact that India has certainly faced significant financial challenges over the decades, you might assume this power under Article 360 has been used at some point.
And this is perhaps the most surprising fact about Article 360 presented in the source. No financial emergency has ever been declared in India so far.
Never. Not once. Not even during the major balance of payments crisis in 1991.
According to the source, no. It has never been invoked.
That's truly remarkable. A constitutional power of such immense magnitude that has remained completely dormant throughout India's history.
It suggests that either the conditions have never been deemed severe enough to meet the threshold, or perhaps the political implications and consequences of declaring such an emergency, including the potential impact on confidence, have been considered too high to risk, even during serious financial difficulties.
Fascinating. Okay, so let's try and synthesize this. We've explored the 3 distinct types of emergencies provided for in the Indian Constitution. The national emergency under Article 352 for war, external aggression, or armed rebellion.
The President's rule under Article 356 for the failure of constitutional machinery in a state.
And the never-used financial emergency under Article 360 for a threat to financial stability.
And we've seen how their triggers, their approval processes, their durations, and their revocation methods all differ significantly. And crucially, we've discussed their profound, often dramatic, effects.
Effects like that fundamental shift from a federal to an effectively unitary structure, the major alterations in center-state relations, the potential extension of legislative terms, and, of course, the significant impact on fundamental rights, though now with crucial limitations, especially regarding Articles 20 and 21.
Exactly. We highlighted how Article 19 rights can be automatically suspended under Article 358, but only for external emergencies now, while Article 359 allows the suspension of the enforcement of other rights via presidential order.
But crucially, how the 44th Amendment created that absolute shield, the right to life and personal liberty under Article 21, and the protections under Article 20 remain enforceable. You can always go to court for those, even in the worst national emergency.
And we also delved into the controversial history, didn't we? Particularly surrounding the 1975 emergency and the very frequent, often criticized imposition of president's rule under Article 356, which sadly seemed to validate some of the framers' initial fears about potential misuse for political ends.
Right, but it's also clear the Constitution isn't static. That experience of misuse, especially in 1975, directly led to the 44th Amendment Act of 1978.
Which, as we've seen, introduced so many vital safeguards. The written cabinet recommendation for national emergency, the need for periodic parliamentary approval with special majorities, the crucial change from internal disturbance to armed rebellion, and giving the Lok Sabha power to compel revocation.
And then the judiciary stepped in, particularly with the landmark S.R. Bommai case in 1994.
Yes, establishing crucial checks specifically on president's rule confirming judicial review, demanding relevant material for justification, establishing the floor test principle as paramount, and laying down clear guidelines to distinguish proper from improper use, all in an effort to restore Article 356 to its intended status as a power of last resort.
So understanding these emergency provisions is really vital for you, our listener, because they reveal the ultimate structure of power within the Indian state, especially during crises. They show how potential threats are constitutionally anticipated and managed, and they highlight that enduring inherent tension.
The tension between the need for a strong, potentially centralized government in truly extraordinary times and the equally important need to protect federal principles, state autonomy, and individual liberties. These aren't just abstract legal clauses debated decades ago. They've had profound, real-world consequences throughout India's history, and the debates continue.
They represent the Constitution's answer to the most severe threats a nation might face. They're designed to provide the power needed for survival, but they carry that inherent risk of centralization and potential overreach, a risk the Constitution itself, through amendments and judicial interpretation, has actively tried to mitigate over time.
So what's the big takeaway here?
Well, here's a final provocative thought, based on everything we've discussed from the sources, for you to ponder. Considering the immense power these provisions grant the center, especially Article 352 and the historically controversial Article 356, how effectively do you think the constitutional safeguards introduced over time, particularly the 44th Amendment and the Bommai Judgment Guidelines, truly ensure that India's capacity to shift towards unitary power remains a necessary, limited response only to genuine emergencies? Or is there still a risk of these powers becoming normalized tools for political maneuvering or suppressing dissent?
Or maybe looking at it from a different angle. Despite all the historical controversies and the potential for misuse, has this fundamental design, the ability to switch from federal to unitary during a crisis, actually been a necessary, even resilient feature that has, on balance, helped preserve India's unity and stability through incredibly turbulent times over the past 70-plus years?
Definitely something to think about as you reflect on this deep dive. We certainly hope you feel better informed about this complex, incredibly powerful, and absolutely critical part of the Indian Constitution.
Indeed. Until next time on the Deuce Dive.